The Supreme Court just delivered a bombshell ruling that fundamentally changes how police shootings are evaluated in America. 9 justices, 0 disagreement, and your Fourth Amendment rights just got significantly stronger. This isn't just another legal technicality that gets buried in the news cycle. This is a seismic shift that affects every traffic stop, every police encounter, and especially every interaction where you're legally carrying a firearm. Before we dive deep into what just happened, I need to ask you something crucial. Are you subscribed yet? Because if you're not, you're missing critical updates that could literally save your life during a police encounter. What I'm about to reveal impacts every single American who might find themselves on the wrong end of a police interaction, and the mainstream media is barely scratching the surface of this story. Hit that subscribe button right now because this information could be the difference between justice and a cover-up if something goes wrong. Let me paint you a picture of what America looked like before this ruling dropped. Imagine you're driving down the highway, legally carrying your concealed weapon. A police officer pulls you over for something routine, maybe a broken taillight, maybe you were going 5 over the speed limit. You do everything right. You keep your hands visible. You inform the officer you have a permit and are carrying. You follow every instruction to the letter. But then something goes terribly wrong. The officer misunderstands your movements. Maybe he gives you contradictory commands. Maybe he tells you to reach for your license while your gun is in the same area. In that moment of confusion, he shoots you. Under the old system in many courts across America, here's what would happen when your family tries to seek justice. The court would put on what the Supreme Court just called chronological blinders. They would ignore everything that led up to the shooting. Did the officer create the dangerous situation with poor commands? Irrelevant. Did the officer fail to use basic de-escalation techniques? Off limits. Did the officer put himself in a position where he'd have no choice but to use deadly force? Can't consider it. All that mattered was those final 2 seconds when the trigger was pulled. This wasn't some theoretical problem. This was reality in 4 major federal court circuits covering huge portions of America, including Texas, Louisiana, and Mississippi. They used something called the moment of threat rule, and it was devastating to anyone seeking accountability for police misconduct. On January 15, 2026, all of that changed forever. The case that rewrote American law started on a highway outside Houston, Texas, nearly a decade ago. Ashian Barnes was driving when Constable Roberto Felix received a radio alert about outstanding toll violations linked to Barnes's license plate. What happened next reads like a textbook example of how a routine traffic stop can spiral into tragedy through poor decision-making. Felix approached the vehicle and asked for the standard documents. Barnes explained he didn't have his license on him and that the rental car was in his girlfriend's name. As Barnes searched for paperwork, Felix claimed to smell marijuana and told Barnes to stop rummaging around. Then Barnes suggested maybe his identification was in the trunk, and Felix told him to pop it from inside the car. Here's where the situation took a critical turn. Felix opened the driver's door and drew his weapon while Barnes turned the ignition back on. When Barnes started to drive away, Felix made a decision that would ultimately reach the highest court in the land. He jumped onto the moving vehicle, literally hanging from the outside of the car as it accelerated. Picture this scene. An armed police officer clinging to the outside of a moving vehicle, his head above the roofline so he can't even see inside the car properly. From this position, while yelling commands that Barnes likely couldn't hear over the engine and road noise, Felix fired 2 shots into the vehicle. The entire sequence from the car beginning to move until it stopped lasted just 5 seconds. Felix went from jumping onto the car to pulling the trigger in 2 seconds. Barnes was struck and died from his injuries, but managed to bring the vehicle to a stop before succumbing. His mother filed a federal civil rights lawsuit, arguing that Felix used excessive force and violated her son's Fourth Amendment rights. This is where the moment of threat rule showed its true ugliness. Both the Federal District Court and the Fifth Circuit Court of Appeals ruled they could only examine those final 2 seconds when Felix was hanging from the moving car. At that precise moment, they determined a reasonable officer would fear for his life, so the shooting was justified. Everything before that moment, including Felix's decision to jump onto a moving vehicle in the first place, was legally irrelevant. Think about the insanity of that standard. It's like saying, if I start a fight with you and you try to defend yourself, I can shoot you and claim self-defense, but the jury isn't allowed to hear that I threw the first punch. That's essentially what the moment of threat rule permitted in police shooting cases. When Barnes's mother appealed to the Supreme Court, something remarkable happened. Something that almost never occurs in our polarized judicial system. All 9 justices agreed. Conservative justices appointed by Republican presidents, liberal justices appointed by Democratic presidents, every single member of the court looked at this case and reached the same conclusion. Justice Elena Kagan wrote the majority opinion, and her words should be etched in stone at every police academy and courthouse in America. The Fourth Amendment requires courts to examine the totality of the circumstances, not just one isolated moment frozen in time. A court deciding a use of force case cannot review the totality of the circumstances if it wears chronological blinders. To drive the point home, the court referenced another case involving a high-speed chase. When police finally stopped a driver after he led them on a dangerous pursuit at over 100 miles per hour, someone argued the final shooting was unjustified because the immediate chase was over. The Supreme Court rejected that narrow view, explaining that you must consider the entire 5-minute sequence of reckless driving and danger to the public to understand whether the use of force was reasonable at the final moment. If you're finding this information valuable, you need to see my upcoming video where I break down the exact phrases to use when police ask if you're carrying a weapon. These aren't random suggestions I pulled from the internet. They're legally tested responses based on actual case law that can protect your rights without escalating a dangerous situation. Make sure you're subscribed because that video could save you from a felony charge or something far worse. The Barnes decision represents a seismic shift for gun owners specifically. Every time you get pulled over while carrying, you're in a Fourth Amendment encounter. The officer has the power to detain you, search you, and potentially use force against you. If something goes wrong during that encounter, this ruling fundamentally changes how the incident will be judged in court. Under the old moment of threat rule, an officer could make a series of unreasonable decisions that created danger, but as long as he felt threatened at the final instant, those earlier actions were irrelevant. The officer could give contradictory commands, fail to use de-escalation techniques, or put himself in an unnecessarily dangerous position, but none of that mattered in court. Not anymore. Now courts must examine whether the officer's own conduct contributed to the dangerous situation. Did the officer's commands create confusion? Did the officer fail to secure a weapon before giving movement instructions? Did the officer escalate rather than de-escalate the encounter? All of these factors are now fair game in determining whether the use of force was constitutionally reasonable. Let me give you a hypothetical scenario that illustrates why this matters so much for armed citizens. You're legally carrying concealed and get pulled over for speeding. You properly notify the officer that you have a permit and are armed. The officer becomes visibly nervous and starts giving rapid-fire commands. Put your hands on the wheel. No, wait. Show me your license. Actually, put your hands back on the wheel. Now reach for your wallet, but do it slowly. You're trying your best to comply, but the commands are contradictory and confusing. In your attempt to follow the latest instruction, your hand moves near where your firearm is located. The officer sees the movement, panics, and shoots you. Under the old moment of threat rule in those 4 circuits, a court might only examine that split second when your hand moved. At that moment, was the officer in fear? Probably yes. Was the shooting therefore justified? Under the old standard, quite possibly. But after Barnes versus Felix, the court must look at the complete picture. Did the officer create the dangerous situation through contradictory commands? Did the officer fail to first secure the weapon, or have you exit the vehicle? Was the traffic stop even lawful to begin with? Did the officer receive proper training on how to handle encounters with lawfully armed citizens? All of these earlier circumstances now matter in judging whether the force was reasonable. That's not just a legal technicality. That could be the difference between your family getting justice or watching your killer walk free. The decision also includes a fascinating concurring opinion from Justice Brett Kavanaugh, joined by Justices Clarence Thomas, Samuel Alito, and Amy Coney Barrett. Kavanaugh spent 6 pages acknowledging how incredibly dangerous traffic stops are for police officers. He's absolutely correct about that reality. Officers do get killed during traffic stops, and these split-second decisions occur in genuinely terrifying circumstances. But here's what makes Kavanaugh's concurrence so powerful. Even after acknowledging all that danger, even after explaining how difficult these instantaneous decisions can be, he still joined the unanimous opinion requiring courts to examine the complete sequence of events. That tells you this isn't about politics or taking sides in culture wars. This is about the Constitution. The Fourth Amendment doesn't contain an exception that says the government can seize you, which legally includes shooting you, as long as an officer feels scared at the final second. It requires that seizures be objectively reasonable, and you cannot judge reasonableness while deliberately ignoring half the evidence. Right now, 73% of people watching this video aren't subscribed to this channel. Don't be part of that statistic. Join the growing community of informed gun owners who get these critical legal updates before they hit the mainstream news cycle. Click that subscribe button because the legal landscape is shifting rapidly and you need to stay ahead of these changes. This isn't entertainment content. These are your constitutional rights we're discussing. The Supreme Court sent the Barnes case back to the lower courts with instructions to reevaluate the shooting using the complete timeline, not just those final 2 seconds. We don't yet know what will happen to Officer Felix. The court didn't declare the shooting definitely unreasonable. They simply ruled that the lower courts applied the wrong legal standard. The case will now be analyzed again, this time examining everything, including whether Felix should have jumped onto that moving vehicle in the first place. But the broader impact extends far beyond this single case. Police departments across the nation will need to revise their training programs. Prosecutors reviewing officer-involved shootings must now consider the full encounter, not just the final moment of violence. Defense attorneys representing people shot by police now have a unanimous Supreme Court decision stating that the totality of circumstances matters in every case. This levels the playing field in ways we haven't seen in years. There's another crucial detail most legal commentators are missing. The Supreme Court specifically chose not to address one major question in this case, and it's potentially explosive. They didn't decide whether an officer loses the right to use deadly force if he intentionally or recklessly created the danger in the first place. Justice Kagan wrote that this issue wasn't properly before the court because the lower courts never addressed it due to their narrow temporal focus. So that question remains unanswered, but the fact that the court mentioned it means it's on their radar for future cases. This has enormous implications for gun owners. Imagine an officer spots your holstered firearm during a traffic stop and becomes nervous. He starts issuing erratic, contradictory commands. Hands up. Show me your license. Hands on the wheel. Now reach for your identification. You're doing your best to comply, but the commands make no sense together. If that officer then shoots you because he interprets your confused attempts to follow his contradictory instructions as threatening, should he be legally protected? Under the Barnes ruling, courts must now examine whether his own poor commands created the confusion that led to the shooting. But we still don't have a definitive answer about whether creating the danger eliminates the right to use deadly force to escape it. That question is coming, and when it does, it could be another game-changing decision for police accountability. Here's what you absolutely must understand. This ruling doesn't mean officers can't use force. It doesn't mean every police shooting will now be found unconstitutional. What it means is that courts must be honest about the complete picture when evaluating these cases. If an officer acts reasonably throughout an encounter and is genuinely forced to use deadly force because of an actual threat he didn't create, this ruling doesn't change that outcome. Reasonable force remains lawful under the Fourth Amendment. It always has been. What this ruling stops is officers hiding behind legal technicalities. They can't act unreasonably for several minutes and then claim the final few seconds justify everything that came before. Context matters. Your constitutional rights don't evaporate because a court agrees to ignore crucial evidence. The information I'm sharing with you today could literally change how police encounters are judged going forward. Make sure you're subscribed because my next video reveals exactly what to do, step by step, when you're legally carrying and get pulled over. The wrong words in that situation can get you killed. The right words can save your life. I'll show you the precise language to use based on actual case law and real-world outcomes. Let me bring this home with the bottom line that every American needs to understand. The Barnes versus Felix decision reaffirms that the Fourth Amendment means something concrete and enforceable. When the government seizes you, whether through arrest or through deadly force, that seizure must be objectively reasonable based on all relevant circumstances, not a cherry-picked moment that makes the officer look good, not a convenient 2-second window that ignores everything that led to the violence, everything that matters to understanding whether the force was justified. This matters tremendously for gun owners because we're often the ones in these high-stakes encounters. We're the citizens who get pulled over and must navigate the complex and sometimes terrifying process of informing officers we're legally armed. We're the ones who need courts to examine the full picture if something goes wrong. Did we act lawfully throughout the encounter? Did the officer create unnecessary danger through poor decision-making? Did the officer receive proper training on how to interact with legally armed citizens? Was the stop itself constitutional to begin with? These questions can only be answered by examining everything, not just the moment when someone decided to pull a trigger. The Supreme Court got this decision exactly right. 9 justices, 0 disagreement, in an era when the court can barely agree on what day of the week it is. That unanimous agreement should tell you this isn't a political decision designed to favor one side in the ongoing debates about policing in America. This is a constitutional decision based on the plain text and original meaning of the Fourth Amendment. Your rights just got stronger. Not because courts will automatically side against police in every case, but because courts will finally be required to look at all the facts before making their decisions. That's not anti-police or pro-police. That's pro-constitution, which is exactly what it should be. The Supreme Court sent a clear message to lower courts across the country. You cannot evaluate the reasonableness of police force while wearing blinders that hide inconvenient evidence. You cannot judge the constitutionality of a seizure by looking at only the final seconds while ignoring the minutes or hours that led to that moment. Police departments will need to adjust their training to reflect this new reality. Officers can no longer rely on creating dangerous situations and then claiming they had no choice but to use deadly force. Prosecutors will need to consider the complete timeline when deciding whether to file charges. Defense attorneys will have new tools to challenge unreasonable force cases. Most importantly, this decision reinforces that constitutional rights matter even in the most chaotic, dangerous, split-second encounters between police and citizens. The Fourth Amendment doesn't include an emergency exception that allows the government to ignore the Constitution when situations become tense. If you learned something important today, here's what I need you to do right now. Hit that subscribe button and turn on notifications. These legal changes happen rapidly, and most gun owners don't discover them until it's too late to matter. The next video in this series covers the 5 specific phrases that can protect you when an officer asks about your firearm. It's based on actual court cases and proven strategies, but you'll only see it if you're subscribed. Share this video with every gun owner you know. Send it to your family members, your friends, your shooting partners. Constitutional rights only have meaning if people know about them and understand how to exercise them. The Barnes versus Felix decision is getting minimal coverage from mainstream media outlets, but it affects millions of Americans every single day. Remember, this is educational content about your constitutional rights, not legal advice for your specific situation. If you find yourself involved in a police encounter or facing legal charges, get a qualified attorney who practices in your jurisdiction. But knowing your rights before you need them isn't optional. It's essential for every American, especially those who choose to exercise their Second Amendment rights. The Supreme Court just reminded the government that the Constitution still applies, even in those final split seconds of a police encounter. 9 justices, 0 disagreement, and a major victory for the Fourth Amendment. Now, you understand what happened and why it matters for your rights, your safety, and your future interactions with law enforcement. This ruling doesn't solve every problem with police accountability in America, but it closes a major loophole that allowed officers to hide behind the moment of threat rule. It requires courts to be honest about what really happened during these encounters, not just what happened in the final moments before someone got shot. For gun owners, this represents a significant step forward in ensuring that lawful carriers aren't victimized twice, first by bad policing and then by courts that refuse to examine the full circumstances. Your right to carry a firearm doesn't make you a second-class citizen when it comes to Fourth Amendment protections. The legal landscape is changing rapidly, and staying informed about these developments isn't just helpful, it could be life-saving. Make sure you're part of the community that gets these updates first, because by the time this information reaches the mainstream media, if it ever does, it might be too late to help you when you need it most. Stay informed, stay safe, and remember that your constitutional rights mean exactly what the Supreme Court says they mean. 9 justices just told every court in America that chronological blinders have no place in Fourth Amendment analysis. That's not just a legal victory. That's a win for everyone who believes the Constitution should be more than just words on old parchment. The moment of threat rule is dead. The totality of circumstances standard is the law of the land. Your Fourth Amendment rights just got stronger, and every police encounter in America just got a little more honest. Now you know what happened, why it matters, and how it might save your life someday.